screen. There we go. Can you see the full screen there?
Yep.
Yes.
Fantastic. That's great. Okay. So, as mentioned, my name is Natascha Maenhaut, and these first few slides are just really kind of an overview of why we might want to think about what happens, or if something happens to us, what might happen to my business. And it's funny, really, because when thinking about making a will, we often think about things such as our properties, our personal effects, perhaps our savings, and perhaps even family heirlooms. But it's surprising how many of us don't really consider what would happen to our business in the event of our death. So for that reason, creating a well-constructed will is really quite essential to making sure that your business is protected, but not only protected, also passed on to the appropriate person in accordance with any existing agreement that you might have in place based on the type of business that you might have. So there are factors to consider when making your will, such as if your business is in a partnership or if you are a sole trader. Many sole traders will wind up their businesses before they pass away. However, if you are still running your sole trading business at the date of death, then what will happen is your business will form part of your estate, and would be wound up either by the executors of your will or by the administrators of your estate under the rules of intestacy, should there not be a will in place. Now, what are intestacy rules? They are basically a set of legal rules laid out by the government that dictate who inherits what from your estate and how much without any input from you. So these differ based on different scenarios. And if you're interested in finding out what that might look like for you or someone you know, then you can actually go to the government website and type in intestacy rules, and you will then get almost like it's an interactive tool that will show you what exactly would happen in certain scenarios. Without a will, there are no executors or powers for the executors to act. So that means that the administrator, which basically is the person handling the administration of your affairs, when there is no will, doesn't have authority until they have received the grant, which can often take a considerable amount of time to obtain. Not only that, the powers they hold may not be as you have intended, and may restrict them in handling your affairs. So this may cause complications, for example, if matters of your business need handling during that particular period. As a sole trader, it's particularly important to have a will in place to ensure that your assets are passed on how you wish, not in accordance with the intestacy rules, as the intestacy rules may not reflect how you wish to leave your estate. So the authority of the executor, and that's the person handling the administration of your affairs, comes from the will itself. And a properly drafted will actually give authority for that executor to start acting in relation to the business as soon as someone's passed away. And therefore that means that the business continue, or the business can continue, and it can help in minimizing any disruption that might occur otherwise to the business as well. Now, things are slightly different when dealing with a partnership, because the options available to your executors or administrators depend basically on the terms of any existing partnership agreement that there might be in place. So it is possible that your executors will have the option to request the partnership to buy out the estate share, or they may be free to sell or transfer it to other parties. So again, there are different options. Quite often in a partnership agreement, it will deal with what happens to your interest when a person dies. And therefore, if this is the case, it's advisable to review that before actually making a will, so that, you know, all those aspects are incorporated, really. As with any business interest, it is possible that the executors may need to sell any interest in a business to ensure that settlement of any debts or taxes, which are the responsibility of the estate. So when considering making a will in relation to your business, it's important to consider the age and personal circumstances of each of the beneficiaries as well. Are they the right people to take on that business? And will they have an interest in it? Because not everybody will have an interest in taking on any business. So these are all things to think about, really. So can you leave a business in your will? Yes. Like most assets, it is possible to leave a business in a will, but it depends on how the business is set up and what position you hold in the company as well. If you own and run your business yourself, and making you either a sole trader or perhaps a sole director, you will be able to pass on your company through a written will. However, if you're one of many partners or shareholders in a partnership or limited company, you won't be able to pass on the entire company, of course, only the share that you own of it. So how do I include a business in a will? Well, it can be done in a few ways. Firstly, you can nominate an individual or a group of people to gift the company to, and this is known as a special or specific bequest. And you can also create a trust to hold the business. This way, you would name beneficiaries for the trust to inherit the company within your will. That also allows you to appoint different people to look after the business versus the rest of your estate. And the other way of really leaving a business in your will is that the company could be left to form a part of your residuary estate. And residuary estate basically just means the rest of your assets. So that really gives an overview of how simplistically that could be done. Powers of attorney, a word that we hear quite often and is often associated with, often people think, well, that's really more needed when we are older and so forth, but it can be important in business as well. None of us want to think about losing our mental faculties. However, if this were to happen, it could have a serious consequence on the running of a business, of course. So it's worth considering what might happen to your business if you were unable to run it and make legally binding decisions regarding it. Lasting powers of attorney, yes, they are powerful tools. Of course they are. And you need to be careful with them. You need to be careful who you actually appoint as well. But they allow you to safeguard your business in these kind of situations. And through the LPA, what you can do is you can grant authority to your appointed people, your attorneys, as they are called in that document, to act on your behalf and make decisions for you. So it ensures that if you cannot take care of the day-to-day running of the business, you will have someone who you trust implicitly with the relevant skills as well, because that's the other aspect that really matters, to be able to carry on your role within that organization. So that gives you an overview, really, in terms of the various aspects of that need consideration when you are considering making a will, particularly if you are a business owner. I've tried not to make it too complicated because there are all sorts of other aspects that can be involved within this as well. And it very much is dependent on what your business looks like and how it is formed. But at least you have a brief overview there. And that's the end of my sharing of information. Thank you so much for your attention. I appreciate it.
Thanks very much, Natasha. If you just, there we go. And I'll just, that's it, perfect. And I'll just stop the recording now so that people can ask any questions and maintain their privacy with that.